Okay, welcome people. I'm Carlina Salguero. I am the founder and executive director of the maritime nonprofit Portside, New York. So the historic ship Mary A. Whalen, a coastal oil tanker, is our home. We're doing the talk on the Mary Whalen today so that you can see some of the ship. It's part of this important story. So I'm just going to come up on board. Now, the Mary Whalen, some changes have been made to her since she served as an oil tanker. So those of you who know the fuel business will see that there is no hose on the cargo boom, no longer any tanker piping on deck, and there's some other changes. I founded Portside, New York to actually work to shape the future, to make New York City's waterfront revitalization more maritime oriented. But in getting a historic ship, we've actually grown the amount of maritime history that we do, and this program is one example. So I'm about to go inside, or as mariners say, down below, and through this computer. So this here is the fiddly, which is the space over the engine and engine room. The Mary Whalen's a bell boat, meaning the engineer responded to bell and jingle commands, bell jingle that came from the wheelhouse, controlling the engine direction and speed there. Portside has been trying to get building space for 16 years. So for now, we do a lot of things on the boat. These are supplies related to our education programs. Those are for the elementary school, PS 676. Here's some photos of the kids. We inspired them to become Brooklyn's first maritime elementary school, and it's the process of growing, morphing into New York City's first maritime middle school here in Red Hook, Brooklyn. So now, arriving in the galley, here we are. This is our curator and historian with the beard there, Peter Rothenberg. Guest, volunteer, supporter, Jonathan Van Duzen, now a law student, and Captain and Professor Lawrence Brennan. So Peter's now going to be showing some historical photos as I get the camera set up. So these are all photos of Mary Whalen when she was working. She delivered gas and kerosene her first 20 years from 1938 to 58. Then she was converted to heavier fuel and rechristened. Her original name was St. Cadieux, the Solomon Thomas Cadieux. In her later years, as you can see, she fueled a lot of ships, both cargo vessels and cruise ships. She was also doing home heating oil, but we don't have any photos of that. Now that's what the Mary Whalen was like. When I first saw her, she was a floating dock and office, or she had been an office, but a floating dock for Erie Basin Barge Port, and she had, in this photo, 12 vessels tied up to her. Other direction, I blew it. So here we go, starting the matter at hand. So the Mary Whalen went aground shortly before Christmas on the 23rd of 1968. This is a photo. There's the Mary in the background. That's the tug Phoenix, which got her off after multiple attempts. This photo has inspired multiple, dance please. Artworks, there's another view over there, very close to the breakwater. This is the Rockaways, Queens, next. And so we have some old newspaper clippings, thanks to the family of Captain Al Durland, showing some articles at the time. Those are on our virtual museum at Red Hook Water Stories, the whole section about the Mary Whalen. So you can see it was rough well. All righty. So anyway, time check. So anyway, to introduce here, Captain and Professor Lawrence Brennan. He has one of those long, impressive bios. So if you want the full thing, go search his name on Fordham's website. I've got a little bit of a synopsis here. So he's a faculty at Fordham Law. He teaches Admiralty and International Maritime Law course. He's handled hundreds of Admiralty and maritime cases. He's been an advisor to the U.S. Department of State, Department of Defense, federal and state judges. He's written extensively on maritime casualties, public international law, and maritime and naval history. We're looking forward to doing some more talks with him. He said he's willing.
Thanks.
Okay, great. Let's see how this one goes. He's a federal litigator for the U.S. Department of Justice. He was a federal litigator for the U.S. Department of Justice. And he's a lawyer in private practice in New York. He's a retired captain, Judge Advocate General's Corps, U.S. Navy, and served at sea and ashore for more than 33 years. Thank you for your service, including record-setting tour at sea on a nuclear-powered aircraft carrier, the USS Nimitz, which launched helicopters during the Iranian hostage rescue attempt. He drafted the presidential transmittal of the Law of the Sea Treaty in the United States Senate. He's been involved in implementing, drafting, and teaching the rules of engagement for more than 3 decades. He served at the U.S. Naval War College for more than 5 years, where he was a senior participant in the annual Title X or 10 Global War Games, and ultimately commanded the NWC's Law Reserve Unit. He acted as a principal legal advisor and chief of staff for combat commanders in the Global War Games of the U.S. Naval War College and War Games in the Republic of Korea. We don't want to have a war with you. He has a particular professional and personal interest in the interrelationship of individual accountability and institutional culpability. As for me, I was previously a photojournalist. I did in-depth self-assigned feature stories, writing and recording oral histories as part of my main work. I founded Portside, New York, as I said outside, for those of you who missed that, to shape New York City's waterfront revitalization, to actually foster more maritime uses of the harbor. We've had quite a real estate story, so 16 years later, we don't have all the space to do what I intended us to do. We expect to get it, we will get it, we are fighters here. But a historic ship, the Mary A. Whalen, entered our life, and with that, we also are very involved in maritime historical matters as well. So, having said all that, one thing I want to mention at the outset, in terms of history, one of the phrases I use often is the idea that sort of history is kind of lost and found. It's not a physical object. I mean, it does involve physical objects like a chair. The chair will always exist. You may have not found the chair or know what it means, but the chair goes on. And I constantly find that people forget about pieces of information that at one point were powerful, impactful, or the information isn't everywhere. So as I looked at getting the Mary Whalen from Portside, New York, I got in touch with Carl Eckloff Sr., who was the owner of the last company to have operated her as a tanker, and asked, is there anything about her that would help us raise money, have a story to tell, whatever? And he was like, no, she's a fine vessel, she served us well. She did go aground once on the Rockaways. No mention of Supreme Court case. And it was about 2 years later when Tom Rinaldi, who's become a ship preservationist and historian, sent an email saying, by the way, did you know? So what that told me is how much more information is on the internet. That was 2005 when I first researched, could not find this anywhere. And I knew for several years after getting about how much the Mary Whalen is loved and respected by people who work on workboats in the harbor. They cherish this boat as a vestige of a former era, but none of them told us about the case. And then I learned years later that in maritime law, admiralty, and elsewhere, this is a really significant story. So I'm really excited to learn more about it. We are recording this talk, and it will go in our virtual museum, Red Up Water Stories, in the Mary Whalen section. So with that, over to you.
Thanks, and thanks for participating and inviting me today, and those of you on the television. Thanks for taking your time on a glorious day. That's not quite summer yet.
But one thing I was, you definitely want questions, right?
Absolutely.
So please, send in a torrent of questions to the chat. Peter Rothenberg is there monitoring those. And also, Lawrence told me that he's willing to run late if there's a lot of interest, another 10 minutes. So if you've got a lot of questions, don't be shy.
Happy to do it. And questions are important, particularly from my perspective. We're talking about a ship that, when it was 30 years old, ran aground, as we just heard. And the owners of the ship sued the government of the United States for fault that contributed to the collision. And the case was tried here in Brooklyn in front of Judge Judd, J-U-D-D. And he decided that it was a both to blame stranding, not a collision, and that fault was attributable to the United States and to the ship owner. He also said, in my opinion, it should be 75-25, but I'm bound by this 1855 U.S. Supreme Court decision, and I must find 50-50. That case went to the Second Circuit Court of Appeals, across the Brooklyn Bridge, not a very far trip, between Eastern District of New York and the Second Circuit. The Second Circuit affirmed, saying the same thing, which is, we don't think it is the right answer, but we are bound by the Supreme Court's holding in the schooner Catherine from 1854, which was representative of international maritime law in the 1850s, but by the 1970s, it was no longer international law. Almost every other nation had gone on to comparative fault, proportional fault in collision cases.
I just want to interrupt one second, because Americans, I think we tend to think like we're the first, we're the best. In this particular story, as I've learned, we were really lagging behind.
Right, yeah, and there's a bit more history, and thanks for prompting that. In the United States, in the 1970s, we were exiting a thing called contributory negligence, which applied in non-maritime law, but had an overlap, which was if a party is even 1% at fault, it cannot recover from a tortfeasor. We went to comparative negligence, and we're going to see that's the proportional fault. The Supreme Court came up in the reliable transfer case. So I have fond memories of my grammar school and high school classmate who taught me the importance of contributory negligence. When we were in third or fourth grade, he got run over by a pickup truck, and the side of his head was somewhat deformed, and he still jokes about that. But he said, I spent all the time in court during the trial learning out what contributory negligence is when he was like 7 or 8 years old, and that went on. He had the good sense to move out to California and become a bankruptcy lawyer. But that's when that issue changed. So we come up to the admiralty. Yes,
so one thing that I learned that was to be responsible for the Mary Whalen and learning about this case as a total non-lawyer is, and I'm going to say this for the people who are not lawyers watching the talk or listening subsequently, is the way, and correct me if I get this wrong, but the way law works, or almost like it doesn't work, you can't decide like, oh my gosh, we really have a bad situation, it's 50-50, we're just going to do away with that. You actually have to wait for a case to show up where that's relevant. So my understanding is, because the Supreme Court and others have been looking for such a case for several decades, and so they're waiting and they're waiting. It's kind of, I find it fascinating to learn that the law is so attached to actual events and reality. It's not sort of like writing policy or advocacy. And so it was quite a while, and then the case the Mary Whalen presents.
Yeah. Inferior courts, which is what the Supreme Court calls every other court in the United States, are bound by the precedents of the Supreme Court. Sorry, did that need to cause a general average incident. But the district judge here and the Second Circuit both recognized, and they also knew from the rumor mill, the Supreme Court was looking for a case to address this. And in fact, there had been a couple of cases out there and they decided different issues. So the Supreme Court took 1 or 2 admiralty cases each year. So the fact that this case got to the Supreme Court out of the entire United States admiralty docket is rare, but the issue was properly framed. It helped that the defendant was the United States of America. The U.S. has a secret way of getting cases to the Supreme Court. It's not secret, it's the Solicitor General of the United States.
It's called self-interest, right?
Yeah, but they also get really good lawyers who have a Supreme Court practice, and they do the petitions for certiorari. The Supreme Court has very few cases where it must take an opinion. Every appeal that is sent to the Supreme Court comes by way of a petition for certiorari, and if they don't get the requisite number of votes, they go away. Thousands go away every year. 100, 150 get taken. And of those, they get decided. Some of them get decided with a 2-line opinion, affirmed on decision below. This was not such a case. They were looking for this, and the judges in the Second Circuit knew they were looking for it. I assume Judge Judd in the Eastern District was aware of it, but the Justice Department didn't there. Having worked in that Justice Department office later, you get to handle the case and you try it and win it, or whatever happens. Probably get yelled at no matter what happens. You should have said, why did you waste your time trying it? Why did you waste the expenses for it? Why did you lose it? Could be lost, but that does happen. So you go there, you handle it at trial, you handle it at the Second Circuit. It goes to the Supreme Court, and people in Washington say, we're not competent to handle this. We're in the Solicitor General's office, we handle this. And they are specialists, and sometimes they're famous professors like Robert Bork, who's the Solicitor General.
I remember that.
Yeah, and whether he read this brief or signed it, I don't know. But the petition for cert was granted. The case goes to the Supreme Court based on the record from the District Court and the Second Circuit. The record is available across the street in the Second Circuit. This case came back and was decided. It was remanded by the Supreme Court. The Second Circuit said, Judge Judd had already given his opinion, 1/4, 3/4 liability, and just entered that as a judgment. There was no second trial, no need for second trial. So
As a follow-up, at some point, I want to put that in a timeline because that is so much legal language. I've got all the lawyers out there follow that. I didn't totally follow
Okay.
that. I don't know if you follow that, Pierre. Did you follow it? You're doing better than I right now. Okay.
okay,
He's very diplomatic.
he is very kind.
He is.
And I
He's
appreciate
that
it.
too.
So the leading case book on maritime collision, which is sort of a narrow version of casualty, you see a lot more things like reliable transfer, strandings and fires, explosions, where there's multiple party at fault. But the proportional fault rule came from collisions and is in some collision treaties that the United States is not a party to. But in the San Jacinto case, which occurred in 1972, the Supreme Court had an opportunity and didn't take it to decide to review the divided damages rule. However, 3 years later, reliable transfer comes up from the Second Circuit, and Professors Healy and Sweeney wrote, quote, "A coastal tanker, the Mary A. Whalen, ran aground at night at Rockaway Point outside New York Harbor, where the Coast Guard had failed to maintain its charted breakwater lights. The master of the tanker, however, had not employed available radar and charts and set his course based on intuition." Not sure it's intuition, but that's what courts seem to use too. And knowing both Professor Healy and Professor Sweeney, they're probably accurate in their research. There was Coast Guard negligence, breach of duty by personnel to maintain that light, which was a cause of the harm, and the vessel owner negligence, again, was breach of duty by employees, the officer, the master of the crew, imprudent navigation, which was a cause of the harm. Noting 75-25% division would be more equitable. The trial court nevertheless said controlling precedent required an equal division of damage. The decision was affirmed by the Second Circuit, a good panel in the Second Circuit.
Can I just show the book? I think the books
Sure.
are out of frame. I like books like this. Look at all the questions.
It's a good book. Professor Sweeney was my professor in 1975. Coincidentally, the year the reliable transfer was decided. In the case book I'm using, which
I think we should speak up. We have a message that the sound is spotty. Peter, you can write back to them and ask, is it low volume or is it that it's the Wi-Fi is breaking up?
okay, I'll try to project a little more.
I can certainly be much louder.
Yes.
But if you can ask the follow-up question.
Yeah.
About the sound. We're
the-
right next to the routers.
The decision was from the Supreme Court explains what happens, but the district court's findings of fact and opinions are particularly helpful, and they tell us a little bit about Mary A. Whalen. So the Supreme Court wrote, respondent, the ship owner, brought the action against the United States in district court under the Suits and Admiralty Act, which governs admiralty claims, and the Federal Tort Claims Act, which excludes admiralty claims, but prudent lawyers don't lose cases on jurisdiction, seeking to recover for damages to the Whalen caused by the stranding and grounding are the same. The district court found that the vessel's grounding was caused 25% by the failure of the Coast Guard to maintain the breakwater light and 75% by the fault of the Whalen. In finding so on the issues of comparative fault, the district court said, and now we're going to quote from the district court opinion, the Coast Guard did not meet proper standards in its repairs of the Rockaway Point breakwater light. This elevated light on the lee shore of a relatively narrow marked channel was an important aid to navigation. The fact was recognized in the designation of light list as required urgent attention and repair of any discrepancy. The nighttime verification of the success of the repairs was essential after routine efforts and proved futile. Such a verification could have resulted in discovery of the need to replace the battery. Gee, how many of us that need to replace batteries?
No battery.
All right, summer reminder, go through the house, check your batteries. And the Coast Guardsman on December 23rd, bosun mate Frederick H. Lee was a competent man, but the circumstances called for active supervision. Okay, maybe he needed a chief or a commissioned officer to supervise him. That's a gentle way of saying he didn't do his job right. Since December 23rd was the last working night for the long Christmas weekend, a proper concern for mariners on the lee shore in a gale should have prompted a responsible officer to verify the flashing of the light on that night. If you fix something, check and make sure it works. I learned that from my father. You may get the back of your hand over your head if you don't do that, but it's probably better than having a ship run aground. And fortuitously, there was no oil spill here.
Yeah, we're very happy that, as far as we know, that Mary Whalen never spilled any.
Which is remarkable considering
She is remarkable.
time. And that's, the Coast Guard needs to note that too. Okay, so the voice warnings by the Coast Guard to mariners were inadequate and misleading, and it was some fault attributable to the government based on it. The fault of the vessel was more egregious. That's a really great word. Lawyers love that.
My mother liked that one.
Did you hear it when she was married to you?
Once I was old enough for words that long. When I was younger, it started with young lady.
Oh, that's kind.
Yeah.
It's better than you. That it was more egregious than the fault of the Coast Guard. Attempting to negotiate a turn to the east in the narrow space between the Bell Buoy No. 4 and the shoal off Rockaway Point, the captain set his course without knowing where he was. Obviously, he would not have found the great water light looming directly ahead of him within a minute after the change of course, if he had not been north of the point where he believed he was. And equipped with the lookout chart, searchlight, radio, telephone, and radar, he made use of nothing except his own guesswork judgment. And after turning in a loop towards the north so as to pass the stern of the tow he was trying to overtake, he should have made sure of his position before setting his new course 073. The fact that a northwest gale was blowing at 45 knots, a serious gale, with 8 to 10 foot seas, made it difficult to see, emphasizes the need for caution. So we see that these are really factual findings. Allocation of fault in major maritime casualty cases is probably the first or second most important thing to the clients and the lawyers. And by clients, I mean two groups. There's the assured, the ship owner, the cargo owner, the other ship. I'll slow down from 250 a minute to something more pleasant. I learned that in Charleston. I slowed down from 400, so we're doing okay. But thanks. But the findings of fact that determine what leads to the cause, or the percentage of causes, are based on what happens. And we still don't agree fully with our English friends on how to do this. But the courts go through this, and we will find out that reliable transfer case is one of the most cited admiralty opinions dealing with fault and allocation. When we talk about the ship owners, the cargo owners, the others interested, we also remember that the ones who are really interested in this are the ocean insurers, the hull and machinery insurers, and the P&I insurers. You look at a different type of case, but you look at the Deepwater Horizon, which was a spill resulting from a vessel, a drilling vessel. And it was the first time in U.S. waters that we had a spill that was of an unlimited amount. In the past, we've had spills from shoreside tanks and terminals, fires and explosions. We've had spills from ships. From the ocean bottom, there was no way to turn that valve once it failed. And that was hundreds of millions, billions of dollars. We've had a number of oil spills like Amoco Cadiz, off France, and Exxon Valdez. That really have burned through the layers of insurance that corporations like Exxon had. And you look at what BP did to save its business and what it's had to sell off because it blew through its policies. And I'm not just talking about self-insured retention of a couple of $1 million, tens, 20 millions of dollars. I don't mean to suggest that's really insignificant money, but in the insurance placement world, there are different reasons and different self-retained or deductibles in layman's terms. But when you get over the policy limit, you get through the 9th and 10th layer and you're litigating the case for 15 or 20 years, like the Exxon Valdez case, it's real big money. We're looking at a case here that's interesting because in the editor's note to the Supreme Court decision in this case book, the United States, they recount the claims. The United States claimed no damages. Damages to the Mary Whalen consisted of salvage expenses, $10,363.
Wow. I would $10,000, what, $363?
$10,363.
You can't do much for that now. It's selfish.
No, I mean, they took it off the salt sand.
Yeah, exactly. It's amazing how such a minor episode, nothing spilled, small coastal oil tanker, salvage that has ramifications for cases as big as Exxon Valdez and everything else, huh?
Yeah.
See, go Mary Whalen.
Repairs, 68,452.
68 to what?
68452.
What they repair?
Now you're going to be upset by this. This changes it. Lost cargo, $6,966. So that implies something. Leaked. It implies it. You need to
Okay.
look at the record more to see.
Okay.
Sometimes it's a paper discrepancy. In 1968, gasoline was probably 29.9 cents a gallon in New York City. So we can just.
She wasn't carrying gas.
No,
anymore.
I didn't do.
All right, yeah, she was
Yeah.
cheap as gas kerosene until 58.
Yeah.
So she's
I just remember the price of the pump at Exxon.
right
Which was Vanessa.
on that route. She's probably carrying. My guess is home heating oil.
Yeah, which was.
She's going and it's Christmas.
Mhm.
So because she's not doing ship fuel out there, so she's going I don't know, Oceanside or someplace.
There's a claim for $1,530 for lost freight, the amount of money charged carrying the cargo, and loss of use, $21,250. So the total claim to a case that goes to the Supreme Court of the United States and has the full attention of the 9 justices and all the people who work for them, $108,532.
That's nothing. I
Yeah.
have to laugh. I have to laugh.
And
I changed history with that.
yeah, exactly.
That's fascinating.
And I know the people who try to settle cases in the Second Circuit, they were screaming. And I also know that when the government of the United States wants not to settle, they don't listen to people screaming. Sometimes they don't even listen to judges who threaten to hold the case. And it's like, gee, we lose cases all the time. And that's what happened. So we have a then 30-year-old ship built in 1938, Christmas 1968. And this case decided in 1975. It took 7 years to get to the Supreme Court, maybe 6, depending on the months. And 6 years, that's a long time for a case, but not that long. Admiralty cases are tried to a judge. There's no jury accepting certain types of personal injury cases, Jones Act cases, and some insurance coverage cases, which will.
Can I interpret the question?
Yeah.
I can imagine why that would be the case, but how did it come to be the case that admiralty cases only go before a judge, not a jury?
It goes back to English jurisdictional precedents and U.S. constitutional precedent that there, and until 1966, there was a separate admiralty docket. When you go to the Southern District of New York, or any district court, you would buy a ticket. You pay the filing fee, and you would get the civil side, the criminal side, and the admiralty docket.
Is that justified on the basis of how highly technical it is and a jury couldn't figure it out, or how it's a leftover?
Yeah, it's a legacy. And we still have that, except in 66, we modified the rules. So the civil rules govern admiralty cases. We no longer have separate admiralty. But there are things we do in admiralty that we can't do in a civil case. We can arrest a ship. There's a thing called civil arrest. So if somebody sues a ship, they can go to the court and get an order of arrest, an ex parte order. You don't have to have the other side there. Occasionally it happens, but not frequently. The judge issues the order. The lawyers go to the marshal's office with the order and the warrant of arrest and the check, because the government doesn't seize ships without prepayment of cost. And they come down and arrest, and the marshal comes on board.
And that's what's happened with the Evergiven in Egypt, the Suez Canal.
That the Egyptians have done that. And
I'm just mentioning that, I'm sure the lawyers know, for non-lawyers, the idea that you can arrest an object. But of course, the object actually comes with people, so you can have your crew stuck in this awful limbo, as is the crew there and in lots of other cases. While people do get out in this kind of legal discussion, the people who are responsible for making sure that ship doesn't do any other kind of damage are stuck on it.
The crew's stuck. You have to have crew to maintain the ship as long as it's operational. And that ship, I think, is at anchor still in the southern part of the canal. Egypt doesn't have maritime. It doesn't have a separate law. It has civil law. So I don't know. My Egyptian law sources haven't found anything particular, and there's all sorts of different theories depending on what non-expert you want to talk to. But that's many billions of dollars. Like the Panama Canal, like lots of U.S. locks and waterways, there are Egyptian rules. The Suez Canal regulations govern, and they do what happens in lots of contracts. The pilot, the Egyptian vessels that assist, become borrowed servants of the ship transiting. and basically ensure that the transiting ship is fully responsible no matter what. Now, that's probably the way the Egyptians would interpret the English translation of the statute or the regulations. I'm not sure that there's any precedent on this. I know solicitors in London who are working on coverage take a different position. I don't know what their authority is for it. And I know the Japanese law firm would take a different position. I know those lawyers and they're quite competent. But that's a big issue because it's very nice to have a pot of money so that at the end of the day, you win the case, you get your money. There's nothing more frustrating than a judgment that's a piece of paper that can't be converted into money. And, even the Japanese owners of the ship and the Korean or Chinese charters, I'm trying to remember. I think it's Korean.
I think it's,
Yeah.
I don't know.
It's Chinese, Taiwanese, Ever Given, I should have remembered. But, they may not have assets to satisfy that judgment. Ships ships of this nature are like taxi cab corporations in New York. One ship, one corporation.
Yeah, and that's why. And when did that start? Is that kind of
Mid 20th century or early 20th century, somewhere in there.
So to explain that again for the non-mariners and the non-specialists, non-lawyers, is you can have a company, so from the outside it looks like there's a company running a whole fleet of ships. If they're moving fuel in particular, what they're going to do is have a separate shell company owning each one to, I don't know if this is the right lawyerly term, but isolate the liability. So if there's an accident with one, then the lawyers and everybody else goes after that, the value of that ship and everything else, not your whole company.
Yeah. When we defeated Amoco in the Amoco-Cadiz case in the early 1980s, which at that time was the biggest oil spill in the world, the judge made a couple of pages of finding of facts piercing the corporate veil. And I've not seen a clearer set of facts. Amoco set up a shell corporation and didn't make it a real corporation. Now, maybe other ship owners now have done different things and are more careful, but it's always been this tradition. If you don't make the corporation and you don't keep it separate, at the end of the day, the shell is going to be a shell, and like the chief judge in Chicago did, he or she will pierce the corporate veil.
Is the following true? I was told that I think it was after the Exxon Valdez that was so monumental they even got out of the business and some of the fuel companies of having their own fleets.
Oh, absolutely.
So Texaco used to have a fleet, Exxon had a fleet. Yeah. At that point, it was like, no, we have oil, and there's another company that's going to actually have the vessels, giving them even more isolation of liability.
And they're totally unclear. There were separate operating companies, and there are lots of interesting, particularly World War II era stories where certain U.S. companies were supplying oil to people who were not friendly to the United States even before December 7th. Texaco and the Germans had some deals that got the chairman of Texaco fired, Cap Reber. And the oil transportation businesses were some of the most profitable parts of the major U.S. oil companies at that time. And that's different. We also have, Open 90 as a result of Exxon Valdez.
Oil Pollution Act of 1990.
And the rules are entirely different. You can't buy yourself a bunker and escape liability if you're in the oil business. Right. And there's, there are real insurance required, and there's insurance run by the U.S. government that can even be available to pay the ship owner if they overpay their pollution cleanup expenses. It's bizarre.
And it's such a change from when the Mary Whalen was built in 1938. She was built for a red-up company, not by them, though they did build boats. That was Ira S. Bushy and Sons, the foot of Court Street, known affectionately as Bushy's. And they were banging out tankers on spec at the time in their own shipyard, and had two other shipyards doing it as American fuel consumption soared. But they had the kind of diverse business that you would never have with that kind of liability concept. In other words, they had a shipyard, they built boats, they repaired boats, they had fuel terminals, and they had a fleet of vessels that moved the fuel. So that ultimately becomes three different kinds of companies. Yeah. You would never have all of that risk bundled together in one family-run company.
No, it's phenomenal. The number of ships that were built in the port of New York and you carry over to the New Jersey ports during World War II are phenomenal, ranging from the battleship Missouri and aircraft carriers up the river at the Brooklyn Navy Yard, little ships like the ones my father was on during the war, 173-foot patrol craft that were built on the Harlem River. They were ship construction in the Bronx and in Manhattan on the Harlem River during World War II. Thousands of ships.
Looking at time, do you have more to say about the case? Because I've interrupted you.
No,
you invited me to interrupt.
No,
do you have more to say before we open it up to other questions?
I'm just going to say, when you shepherdize a case, you look for the legal history of the case where it's been discussed or cited in an opinion. In admiralty and maritime law, especially dealing with allocation of fault and damages, this is the most frequently cited case. It is controlling. It may not be squarely on point, but it is controlling in every case. A collision case, a grounding, any sort of maritime fault that is a casualty that is there. And I'm sure it also applies in some coverage cases, but I'd be happy to try to answer some more questions if there are.
One, before we go out there, I wanted to bring up, this is just something that you actually, you told me as we were discussing on the phone, is that there was a shift in the naming of cases, that previously they had
Yes.
ships named, and I'm so sorry that that changed, because this would otherwise be known as US versus Mary Whalen, right?
Yep.
But it's the company Reliable Transfer, which was a shell company that owned just this vessel at the time. So tell us about the change
Sure.
of case name.
Yeah, in the 60s, probably coincidental with the change of rules to from the admiralty rules to the civil rules. The convention for just calling a ship a case by the ship's name, the Titanic, the Mary Whalen, that ended about 1970, and
It's too bad.
it's unfortunate. This case is also a little different because the owners of the ship, not the ship, sued the government of the United States. So it's Reliable Transfer Corporation, the owners of the ship. But you would have seen in American maritime cases until sometime in the 60s and 70s, the ship name, and that's what we would talk about when we talked about ships. One of the U.S. Navy cruises, Chicago, was in a horrible collision, and there were real questions about the evidence being saved or destroyed or altered. And you cite the USS Chicago case, and that's still there. That's in the American maritime cases that are available online, but require a subscription. Federal cases are still published, and they are mostly there. The other naming issue that is interesting is the parties are flipped when it goes to the Supreme Court often.
Oh.
The name of the party who petitions for certiorari goes first. So the United States was nominally the defendant, and having lost because it had to pay half, not a quarter, it was the petitioner in limitation. So it's U.S. versus Reliable Transfer. The case at trial and in the Second Circuit, it's Reliable Transfer versus the United States.
Interesting.
That gets you through the first week in legal research in law school, but it's really a footnote.
New to me.
Mostly a footnote for us. So
Okay, what kind of questions have we got out there? Jonathan, since you're president and now a law student, do you have a question?
Yeah, I guess having only been in 1 year of law school so far, when you're looking at this this case and how it affects apportionment of damages going forward, I guess can you talk a little bit about how that relates to the U.S. v. Carroll Towing hand formula case that Judge Hand came up with?
Learned hand?
yes,
Learned Hand, yes.
The
Favorite
less
judgment.
Probability that a ship could break away from its mooring, gravity resulting of the resulting injury, and then the burden of precautions. And
yeah, I'll give you the better case. One I think is better. It's the Steinbrenner case, the Buffalo Bridge case on foreseeability
Okay.
and damages, and it's wonderful because the district judge and the Second Circuit talk about the credibility of the young executive in the family business, Kinsman Transit, George M. Steinbrenner, who obviously
The
was
same.
one and same, George M. Steinbrenner
Really?
III. He was obviously too busy to do his corporate duties because he was going to Tampa, Florida for the winter. And there's this doctrine which really goes back to Folsgraf and the other cases, Folsgraf, the Long Island Railroad case, where somebody was carrying dynamite and blew up passengers of it.
That's a bad.
Yeah.
Huh?
But should the railroad be held liable for someone doing something? Is there an end?
and on their property, and
Is there an end to the chain of causation or foreseeability? And this goes back to your really important question about the Ever Given. You know, what can you foresee? Can you foresee a 400-meter ship crossing the canal and wedging like a pencil? And if you've ever tried to pull a pencil out of something really narrow cup, you know how difficult it is. That's complicated because of the tide. It really was fortuitous that it was a portably high tide, and they got enough dirt moved in time. But is there a point where you can't hold someone liable or shouldn't hold someone liable down that line? So Hand is one. Some prefer Augustus Hand to his cousin, Learned Hand. Having met lawyers who argued in front of them, they seem to like Gus as a judge for the exam. Everyone said Learned Hand was the 10th member of the Supreme Court. He was highly respected, but he and his cousin never got to leave fully square. We have some more questions from the audience?
Nothing yet, though I will ask
Please.
one question. But I mean, maybe you sort of talked about it a little bit. I'm just sort of thinking, now, since the amounts are so low in this case, I'm just wondering why Reliable bothered to make a fight over this all, because wouldn't they then have to pay all these lawyer fees, which may have actually been more than the damages they would have to pay if they paid everything?
Two possible answers. One,
Unfortunately, Carl Eckloff just passed away about a year ago. I really regret not having interviewed him.
yeah,
Was he ornery?
No, actually, when he died, I have to tell you, and mariners will tell it to you straight, like who's DICK or whatever, but there was just, the harbor was effusive in their praise of him as a gentleman and a fine man and a great man to work for and everything else.
Yeah.
And
this was a test case. The insurers, marine insurers, were interested in getting an answer, and the government was interested in getting an answer, and the courts were, and people in the Supreme Court looking for sending lawyers from 1968 to 1970. The great today. So the dollar bills, but this was sort of a cold case, and it was the United States. Now, having once tried the case and having gone to the Second Circuit and essentially won in the district court and a circuit court, they were stuck.
right, who they is stuck. I can see why the government is interested. Right, so Reliable starts. So once they're in, they're stuck with law because of the federal government's interest.
Yes, the government having lost.
Just need to clarify that, not the lawyer that I'm just getting out.
Very real interest to stop having won twice. And now the government says, no, you're not going to win from the Supreme Court. Well, either you settle the case or you trade or something. They forced to trade. And I haven't read the briefs in a long time. I don't know what they look like, but I know the Justice Department puts in as much effort in $100,000 cases for a case with evidence. I mean, they're good, right? And this is one they wanted. And I don't think any other defendant would have gone up. Now, the second part to your question is, how does a case get to the federal court? And there's different types of jurisdiction. Admiralty jurisdiction, there's no dollar amount. But most federal civil cases go in what's called diversity jurisdiction. Quick answer is citizens of separate states, so two New Yorkers can't get to federal court. And then there's special rules about foreigners. But they must be diverse from different states. And the amount in controversy, the amount of the lawsuit has to be at least $75,000. So you don't want, if the guy from New
Right,
I live
small
in New
claims
Jersey.
court goes to
Yeah.
the Supreme Court. Exactly.
But we have that in Admiralty. We have lots of cases, particularly Jones Act seaman injury cases, where the amount can be very small, and the court has to take it. There's no choice. They may growl and yell, but they have to give justice. So that's part and parcel. And you also find as a litigant, a lot of times your client gets tied up in the litigation. You don't see it at the beginning. All of a sudden, like this one, it's, oh, well, we won. And any other defendant of the United States would say, okay, there's a number between 50-50 and a quarter. What is it? What will you take to go away? Because we don't want to pay the legal fees.
So what happened actually in the legal fees in this case or in general in that era?
In this era, the United States absorbed its own fees. Mary Whalen absorbed its own fees. Mary Whalen got 25% of whatever the damages are. So 4 into 108,000.
So knowing what you know about fees back then, do you think that this was like a lost leader? So if they had $542,000, I wrote that down.
Yeah.
So I didn't have that. So they probably spent more than that on the legal fees to lose.
Yeah, because let's just do the whole thing.
So be careful about suing the federal government.
Particularly you're in for the.
That's what I learned in law school today.
Yeah, but I mean, it was tried in the district court. It's a bench trial. Maybe the judge took a lot on paper and deposition transcripts as opposed to live testimony. We can find that record's there. It went to the Second Circuit. That's a big effort. You've got to write at least one brief. The government had to write two, maybe more. And then to the Supreme Court, you have to petition for cert, and then you have to have main briefs and answering briefs. And then you go back to the Second Circuit. And what was the only efficient thing was done here, and I think it was either Judge Feinberg or one of the other superior quality judges at the time, and said, look, in the first trial, Judge Judd said it's 3/4, 1/4, but I can't find that because the Supreme Court finds me to 50-50. If you send it back to him, there's no new evidence. He is not going to change his mind. So that saved, another trial, another appeal. So we wound up with that type of decision here, efficiency. But there are cases that, are like a Wimbledon tennis match. You just watch them go back and forth, and it's worse in state court. Federal appeals system is designed to have very few appeals. There are exceptions, but the final judgment rule applies in civil cases. So don't go up there because the judge did something in a preliminary hearing that dissatisfied you. You can do that over in New York State Court. New York is very broad appeals. The federal court, there are exceptions, but not that many to interlocutory appeals.
Does that answer your question here?
I think so, yes.
Do you have another one?
Someone just wrote in asking, I'm curious, how do courts today go about apportioning fault in marine casualties?
They follow a reliable transfer, and they cite it. And they cite the cases in their circuit that follow a reliable transfer, and they take evidence, factual findings as to how it's done. What did the ship do wrong? Officers of the ship, or what's unseaworthy about the ship? What caused or contributed to the casualty? You have a captain who has false papers. It does happen, not often, but there are places where we've seen officers and men have false mariners' documents. And the largest recovery I was ever involved in for Tokyo Marine was fake documents from the Philippines for the crew. A long time ago, the ship ran ashore on a well-charted reef and toward the bottom out. So we find different types of cases. We find something happened, and unless it's an act of God or something, it's not going to happen. There are differences with allocations in insurance disputes. We could spend the rest of the year talking about that, but insurance coverage disputes are slightly different. But you look for the contributing facts and probably take expert witnesses who put together the facts. You have to be careful that witnesses don't testify on the ultimate question. You don't want the witness to say, Judge, in my opinion, if I were you, I find this all there. You want them to say, these are the 7 factors that the opponent did that contribute. Oh, and if you look at this fact that it's attributable to the party I'm testifying for, yeah, maybe it's fault, but it's non-causative. And then the argument I like to use all the time is synergy. It's one of my favorite words. It's more of an engineering concept, but it's when you have multiple faults, when what hits the fan. So if you have 3 or 4 things that are going bad at one time, and then it all comes together and it blows up in your face.
In a storm.
In a storm,
Exactly.
exactly. But it's worse than the sum of the individuals.
Yeah.
And when you lose steering as you're trying to cross somebody's bow, that's really bad.
Yes.
And that's what happens. So, I don't think you can add faults 1, 2, 3, and 4 and say they range from 5 to 10% each, and whatever the math comes up. You can do that, and then you can compare that with all of the factors happening concurrently, and you do the same with the other. You have to make sure the number adds up to 100. And it gets this and some other cases on allocation have really screwed up settlement in big maritime cases. Because when you settle, it does certain things with respect to the claim over against the remaining parties. So it makes plaintiffs who say, oh, I can get 10% from the defendant, and that's a lot of money, I'm guaranteed 10%, and lawyers guarantee 10% of the claim. But the other the other defendants will then turn and dump on the empty chair, and that can have some impact. It's much more difficult. I'm explaining in 2 minutes.
I have something, unless we have another question from the chat.
Go ahead.
So I'm just gonna, segue over to a little bit of kind of folk history and actually a request for information from anyone who's watching, but this is gonna go online. So, what I've been told, through the harbor, actually, I have to say Facebook has been a great resource, for old timers bring us information, was that, one of the photos that we showed early on, in aerial from a helicopter up in Mary Whalen, aground with the tug Phoenix, that the owners, there were 3 owners of the tug Phoenix, and they had a painting commission. So each owner got a copy, original, of this painting. We don't know where those paintings are now. We've never seen them. We would really like to see them. And then a number of years ago, we got contacted from, I think his name was Walter Barstow, via Facebook, who's like, I have this painting in my garage, and he's elderly. I don't think anyone of my descendants is basically going to want it. Would you like it? And that is this painting here, which he said was painted by a crew member of the tug Phoenix, based on the very same photo. So this is a kind of folk art version, but not the paintings commissioned by the tug owner. So if anyone knows where those 3 paintings are, or one of them, we would really love to see a copy. And then the way inspiration goes down through history, there's an amazing maritime artist and also rigger, Frank Hanneman, who saw that painting in our office and sent us a felt version. So if you want, you can look up Frank Hanneman online. But yes, we would love some help finding out about those paintings there. So I don't have another question at the moment. Does anybody else? We have 5 more minutes to go. Well, Captain Professor Lawrence Brennan, he was willing to actually run over if we had more questions. I don't know if there's anything else you want to point out.
Yeah, I'll do a quick sort of dance of the Port of New York. We're sitting here
Here we go.
not far from where the first U.S. submarine attacked a British warship
Yes.
in 1775 or 1776,
Sure.
I think. Turtle. And it may have been a Yale guy too. I'm not pretty
I
sure.
know, but there's a
Design-
local artist who memorialized that, Duke Riley, recently.
Yeah, but I think it was Bushnell, and
Yeah.
the guy, it was a hand propelled, and the attack failed largely because of the copper sheathing under the hull. If you go to Pearl Harbor, there's Battleship Row, and we all know of the December 7th story in the Battleship Arizona that's there. And in the last 20 years or so, the Battleship Missouri has been moved there. It's a great place. I've rented out the captain's cabin as a conference room to take depositions of some Japanese clients. But
It's really rubbing their nose in it.
it was Mitsubishi. So it's Arizona's here, Missouri's here. They were both built upriver at the Brooklyn Navy Yard. One of the many problems with New York as a Navy base and a Navy port, and the Kennedy administration is the one who brought the end of it, is air draft. The height of the Brooklyn Bridge, and
Which is low.
yes, there's not enough clearance. And you'll see there are photographs of some of the late conventional carriers that were built there, including Constellation.
Just sneaking on.
Yeah, no, they actually folded them.
Oh, yes, the mask.
The mast folded.
As
Some
I
of
do
them,
now.
yeah, some of them did folded at the top. But this Constellation, which had this horrible fire the day before, I think it's the day after, the crash between a jet and 2 passenger planes over Brooklyn that killed hundreds of people in Christmas 1960.
Yeah, right up here. That was not Broadway Park Slope, actually.
And one of the planes crashed near where my grandparents lived in Staten Island in Miller Field, and some kids survived for a couple of hours. It's a horrible story, but there's a lot of history here. John Holland, who invented the first U.S. Navy submarine around the turn of the century in New Jersey, in the Port of New York, and some of the tests were off the South Shore of Staten Island at Lemon Creek. There is a lot of history in New York, and it is not very well represented or preserved. I can't tell you what naval establishments are still in New York. I drove at Fort Wadsworth and Floyd Bennett Field and a couple of other places in the 70s, but there are no longer ships based at the Navy Yard. Or
Right, the Navy Home Port Pier in Staten Island is no longer Navy Pier.
Yeah, we had a ship home port there for at least 6 months, and it was a tremendous waste of money. But there's a lot of history, and there's a lot of tradition that is disappearing. The youngest World War II veterans were born in 1927 and 1928. Do the math. They're well in their 90s.
Right.
And the Korean War veterans are maybe 10 or 15 years young at most, probably 10. And then you get to Vietnam. So the history that's here really post the closing of the Brooklyn Navy Yard and the end of construction of ships 20 years after World War II, it's changed dramatically. But on a positive side, New York is still the principal financial center of global international trade. Two things, banks and insurance companies. Anyone who thinks that I have intentionally said adverse things about insurers or banks, you're mistaken. They're my favorite people in the world. They make things move. There's at least $40 trillion of global trade that goes by sea a year. Maybe the people who do fashion, pocketbooks, and shoes can afford to send $500 shoes by air. But most of what we buy and sell, commodities, oil, grain, goes by sea. A lot of it doesn't go on U.S. flagships. We could have a discussion for the rest of eternity about the Jones
Act. That'll be another lunch.
We can do that. And there are multiple arguments, but whatever ship, whatever container, whatever bulk carrier, whatever oil, take the ferry across someday, nice day, and go both ways, and look at the tankers that are lined up in the small barges and tugs that have replaced the massive T2 tankers of World War II. So if you have any interest in financial global trade, think of the $40 trillion a year in the economy. Think of the banks in New York and the interrelationship of the banks and the insurers, because damn near everything that moves is insured. Right. And you can see on the size of the new container ships how many hundreds of millions of dollars are at risk.
Right. Well, on the note of history, I'm going to put a plug in for our virtual maritime museum. It's called Red Hook Water Stories, plural.org. It is about Red Hook, but you can really see all of New York City's maritime history in microcosm in Red Hook because of the nature of what happened here in every kind of way. And it's a growing resource. We will add talks like this. We do oral histories. There's ongoing research. If you think you've got something to contribute, please get in touch. There's a contact page on our website. And the other thing is, if you'd like to support us, we always appreciate it, but we are, thanks to the pandemic, particularly impacted financially. So we accept donations on Venmo at Portside NY. Our website, which is Portside New York, spell out the New York.org/donate. Okay. And do we have any last minute questions, or are we going to sign off actually on time?
I think we can sign off on time.
We're a minute late, actually. Okay. Any last one from you? No, Jonathan. Anyway, thank you very much. I really appreciate this. Thanks all of you who attended. PortsideNewYork.org. All right, over. End the meeting for all.